So yes, my thumbnail is a direct reaction to videos put out by other creators. I'm going to call a spade and say that one particular creator is going to go after Detective Tagler in a somewhat misogynistic manner, no matter what she does. That is my opinion, and I'm going to stick to it. I have removed anything on there that would identify that creator, but just to put a title out there saying Detective Tagler gets destroyed on the stand tells you exactly what you need to know about how he's going to assess Detective Tagler's performance during this hearing. I'm not going to watch this video, but I'm willing to bet that you will not once hear mention of how well she stood her ground, how she corrected the defence lawyer, how she did not for one moment back down. She was confident that she had done her job correctly, and you could tell that from the way she asserted herself throughout. Sure, the defence were a little bit aggressive in the way they interviewed her, but you know what? She corrected them when they made assumptions. She refused to be brought into any sort of speculation. She was a solid witness. You could not, from her witness account, turn around and claim, yep, they're admitting fault now. You could tell from the way she handled herself that Detective Tagler knew she had done nothing wrong. She knew that she was solid in her decisions. She had consulted with her supervisors over the actual seizing of the phone. And despite the aggressive approach of defence, she did not once display any doubt over her decisions. So that's why I put my heading. We had another creator who made their title, "Did the police make a massive mistake in this major criminal case?" Again, taking the stance that Detective Tagler did the wrong thing when she seized the phone. I should probably just mention here the ape on that thumbnail is actually one that I inserted there myself because there was an image of Stephen Stearns and I'm just sick of looking at his face right now. So I guess what I'm saying here is that I'm really frustrated with creators who are covering this case and are either inserting a major bias. Now, I've probably got my own biases, but I check that. One of the things that I love about all the comments I get on my videos is that there are people who do question my ideas. They do question my thoughts and they question my conclusions, and it keeps me honest and it keeps me continually assessing the way I'm covering this case. But what I see here is creators who are set on a mission. This one creator who really dislikes Detective Tagler and takes every opportunity he can to have a go at her, when to me she's one of the standout detectives in this case. We get creators who are so busy covering so many other cases that while they do claim they've had a deep dive, their deep dive pretty much just consists of going through any new documents, going through any new interviews, but not really going any further from that, and not looking at particular topics, not really digging in. You get the creators who look at the various motions that have been made by the defence team and the responses made by the state, and don't stop and apply logic or critical thinking, and therefore get stuck on whichever argument appeals to them the most, without actually weighing up both sides of the coin. Sadly, a lot of the time, these creators that do take that approach of basically just choosing the argument that suits them the most, choose the stance that's going to get them the most clicks. Of course, if you turn around and make a title of, "Did the police make a massive mistake in this major criminal case?" you're probably going to get way more views than turning around and claiming that a detective was a solid witness in the case and no, those motions are going to be thrown out. It's just the way it works, because it's fear-mongering and it's pandering to people's own concerns. Not only are you going to get more views if you choose to scare people more by saying, "Look, this is what could happen," but you can draw it out, you can turn it into multiple videos. And of course, if you are a huge content creator with a huge number of subscribers and you get a large number of views with every video, there's big money in that. So I'm more than happy to be the little content creator who only gets 800 views on my videos, because I would rather reassure people with logic, common sense, and critical thinking than buy into the practice of scaring people to get views. Because that's essentially what a lot of these creators are doing. They're looking for a negative viewpoint, something a little bit more scurrilous, that is going to get people curious. And of course, with a case like Maddie's, where everyone is so emotionally invested, if there is a suggestion that there is a problem with the case, that the case might be thrown out, people are just naturally curious. They're going to click on it because they're afraid that that could be the truth. They're going to click on it to find out why this claim is being made. So, having said all that, and of course knowing that my opinion means nothing to those creators and they really don't care what I say or what I think, I'm going to start talking about this motions hearing. It was long. We didn't get to hear the last part of it because there was some sort of glitch with the visual, the audio and the visual. I think that was connected to the fact that they had allocated 3 hours for the hearing, and I think someone who set up the feed must have set it up only for like 3 hours or something, so that it basically cut off pretty much after 3 hours, and we missed the arguments with regards to the warrant, the Google warrants. That said, I think we can guess from that the defence really didn't have much to offer there. I think we know the arguments because essentially they only called one more witness. The defence didn't cross that witness. So I do believe that, based on the other motions that they heard that all we missed out on was the defence just reiterating what they had put in their original motion, and the state doing a rebuttal, probably proving the inadequacy of the case law that was used by the defence, because that seems to be what we've seen so far. So, on that note, let's start talking about this motions hearing. So, the three motions that were being heard today were the unlawful seizure of the cell phone, unlawful search of the cell phone, and the Google evidence warrant, basically saying that that was fruit of the poison tree because it resulted from the seizure of the phone and the illegal search of the phone. The first thing that I thought was really good was, of course, hearing Judge Carsten pointing out that he had taken the effort to go and check out evidence. He had got 3 audio interviews and listened to them. The first one was the interview with Detective Hunt on the 27th, which was around lunchtime. Then he listened to the 2 interviews that were Detective Tagler and Detective Aosta. So this, of course, means that no matter what angle the defence tried to put onto their argument, no matter what way they tried to twist the interpretation of the interviews, Judge Carsten heard it for himself. This is a highly intelligent individual who is more than capable of listening to these interviews and making logical deductions from what he can hear. I'm pretty certain that when he listened to those interviews, he could hear what we hear, and that is that Stefan gave consent multiple times. Not only that, but there was plenty of probable cause which came directly from those interviews. And there were exigent circumstances because Stefan admitted to resetting his phone. So that straight away allowed me to feel confident that Judge Carsten is certainly going to make the right decision in terms of these motions, and unless my ability for reason, logic, critical thinking has gone out the window, I'm pretty certain that when we get a response from him, it's going to be to throw these motions out. There may be a few things where he points out in future this could have been done better, but I think overall he's going to say, no, motion's denied, carry on. Now, in terms of his ruling, there is actually stuff on the court webpage which basically says that he will issue a written ruling. So I will go over that when it is released. I suspect that it won't take long. I think it will be clear and concise with good reasoning, good references to case law, something that will be probably quite logical and straightforward. After all, this guy, as well as working as a judge, has worked as a lecturer and specifically in case law. He knows his stuff. I feel super confident in Judge Carsten as being well equipped to handle this case. Now, let's talk about the defence. So, they came out the gate claiming that if consent is deemed valid, because at the end of the day, it does appear that Stefan definitely gave consent to Detective Tagler to look at his phone, and he also gave consent for them to take his phone. Likewise, he gave consent for them to download his phone. But at this point in time, this is in relation to the supposed unlawful search of the cell phone. So the defence came out saying, well, if consent is deemed valid, then the scope of the consent was exceeded, claiming that, as we've seen in their documents, they believe Detective Tagler went beyond the scope of consent. They also then tried to claim coercion. Basically, Detective Tagler and Detective Aosta coerced Stefan, and he's trying to claim that he acquiesced because it was police authority. In other words, Stefan's a goody two-shoe who's going to do the right thing, and because it was police he felt that he had to, which is, we know that's not the case with Stefan. And he also then tried to claim impairment by lack of sleep or ingestion of a sleep aid, which we'll come back to that because when we hear the testimonies, we know that that can't apply. They also claim that there's no exigent circumstances. And they basically claim this for both the unlawful seizure and the unlawful search of the phone. In terms of the warrant for the Google Drive, they claim that whole fruit of the poisonous tree argument, and there was lack of probable cause. The state, in their rebuttal to that, basically once again went to, it was a consensual search. He gave consent multiple times. They had probable cause for seizure, and that there definitely were exigent circumstances that existed. In terms of the Google warrant, they pointed out that actually it wasn't fruit of the poisonous tree, because for the judge to have granted that warrant, then basically there are legal requirements which have to be fulfilled. For a judge to approve the warrant, there has to be adequate probable cause. There's got to be enough legality to the request. They pointed out basically that in terms of applying for the warrant, if the judge considered the phone evidence acceptable, then the burden of proof for the warrant has been met. And that way, the only way the warrant could be overturned would be if law enforcement had lied or falsified evidence in their affidavit, or if the judge had somehow abused their position and made a decision that could be considered unlawful. And as I mentioned when I went through the rebuttal from the state, this is something that under law is basically, I wouldn't say discouraged, but it is not ethical to do so unless you've got a damn good reason to do so. Meaning that judges don't lightly overturn decisions of other judges. And basically by requesting to have this Google warrant thrown out, that is essentially what they are asking here. They are asking one judge to overturn the decision of another judge. The Google warrant no longer, once it's been approved, it is no longer an issue of the law enforcement having done the wrong thing. They also spoke about the good faith exception, basically meaning that since the judge approved the warrant, then the good faith there is that the warrant has been approved, so there is no reason why they cannot access the Google Drive and all its contents. Essentially, the argument there is once it's been approved by the judge, they're not doing anything wrong by actually going into the Google Drive and you doing that Google Drive search, downloading the contents, etc., because it's been approved by a judge, a higher power. Going back to, once again, you're got to have a damn good reason to overturn a decision made by the judge. So basically, the point of law that they're giving here with the Google warrant, and I will keep going with this because, like I said, we don't get to hear this part of the hearing because it cut out. But basically, the legality of the Google warrant is sound. They cannot overturn that. There is no evidence that law enforcement lied or falsified evidence. And in terms of saying that the judge did anything wrong, well, the state has never said anything in their arguments that would suggest that they are in fact going after the judge. So we can be confident that the Google warrant, the motion to exclude that as evidence or the Google information, we can be confident that that motion will be denied because the law is extremely clear. I don't know what sort of argument the defence may have tried to give, although I suspect, given their arguments for the other two, I don't think it would have been any different to what we saw in their motion. So I feel confident about that. Now, we had Stearns on the stand with Alicia Smith doing the questioning. At least this time round, she chose a potentially more professional hairdo. Why I'm a little bit reluctant to judge there is because, obviously, as an Australian, my understanding of certain cultural things in the United States are limited. So while I could quite confidently say that you will never see a female lawyer in Australia go into court with a Mickey Mouse hairdo, I can't say for certain that that is actually acceptable for a professional in America, or that it's not acceptable for a professional in America. Although from an Australian perspective, I did find her hairdo more appropriate. Like I said, that just could be me having a different perspective coming from a different cultural background. Now, as you would expect, Stearns, of course, played the victim here. And the thing is, that didn't do him any favours by putting him on the stand, really. Because, like I said, who's making the decision here? It's not a jury. You're not trying to convince a jury. You are trying to convince a judge who is highly educated, a judge who has listened to all three of these interviews, who has looked at all the documents, and is more than capable of making intelligent, informed, critical decisions. So getting Stephen on the stand and having him claim that All he agreed to was for her to check his Google Maps and check that he was logged on to Google was a mistake. Because we know that was just the tip of the iceberg. There was more to it than that. She requested to look at his history. She didn't say specific history. She wanted to look at his history. She wanted to take a screenshot of his history, which she did, or a photo of his history, which she did. But he's trying to avoid that because he's trying to argue this whole exceeding the scope of permission. And then, of course, she asks him, well, did they have a warrant to look at your phone? And he's like, no. So we then had Danielle Pennell doing the cross-examination. Now, I just want to point out that she looks like a lawyer who works damn hard. She looks like a lawyer who could use a little bit more sleep. And we know she's a damn good lawyer. She did the Todd case with Judge Carsten. She knows her stuff. You've heard her speak. She is damn good. So the first thing she did was establish the fact, basically through asking Stefan questions, she established the fact that he had given permission multiple times for different things. He had continued to give his permission. Detective Tagler had continued to request his permission. So she confirmed that from him. Then she asked him if he saw what Tagler was doing with his phone. And he claimed that she walked away and began searching nonsense. Again, not doing yourself any favours there, Stefan. Because actually when she walked away, you had your phone in hand. And you can actually hear it on the audio when she hands it back to him. And he does, in fact, say thank you or something along those lines. And of course, Danielle Pennell straight up pulled him up on that. She is so familiar with these interviews. She knows her stuff. She knows all the legality. She's not going to let any of this pass. So, basically, isn't it true she handed the phone back to you? And he grudgingly admits, she told me to input my password because it was locked. So, he still tried to avoid admitting that actually he was holding his phone when she requested that, because she had given it back to him. So he's trying here in court to avoid answering that she gave the phone back to him. He's trying to talk his way around that. Like I said, thankfully the judge has heard the interviews. He knows what happened. And I would imagine that in making his decision, based on what went down in court during this session, he probably then went and listened again. My thoughts on Stearns as a witness was that it was a dumbass move to call him as a witness because he didn't do himself any favours. He didn't give entirely honest answers. And of course he did his usual thing of trying to avoid giving answers. The amount of time that was spent interviewing him, I don't think there was anything really hard-hitting there from his lawyer. And I think, Danielle Pennell just basically proved what we saw later on anyway, and proved that he's a big sookie lala who can't take any sense of accountability. So it could have actually been damaging for the defence to put Stearns on the stand. So the first witness they called was Detective Frank Hunt. I'm learning from Detective Tagler not to say his name all in one. If you haven't figured that out yet, I'm not going to explain it on here because I would get demonetised. Now, I have to say, and I think I was in the docket at this point when I was watching this. I started on one channel, and when there were all the issues with the audio, I went hunting for a channel that I knew would have tweaked the audio. I tried one and she kept pausing and giving her own narrative, which I didn't want. Given that I had gotten up at 4 o'clock in the morning, I didn't want to be spending 4 or 5 hours watching a live stream. I just wanted to watch the live stream. I didn't need someone else's comments along the way. So I went to the docket. He had picked up the audio better. And I did note that a few people commented in chat, like me, that Detective Hunt is nothing like what I imagined. And I think a few other people said the same thing. I actually thought he was an older detective, so I was quite surprised when I saw him. I think, like all the detectives, he definitely came across as professional. He was extremely clear with his details. I gather these guys know their stuff. They make sure before they go into court that they are clear with what occurred in these interviews so that they can answer accurately. So we had Danielle Pennell interviewing him first, and some of the important points that came out here is that he believed that Stefan had woken up about an hour before he did this interview at 12 p.m. When asked how he knew that, he basically pointed out essentially that, first of all, when he was interviewing Jen Soto first, Stefan was upstairs in the townhouse, but also because basically that's what Stefan told him. Meaning it's on that interview, the judge will hear that for himself. Why is this significant? Because one of the arguments being put forward by the defence is that Stefan shouldn't have given permission for the phones. He only did so because of lack of sleep. And yet we know that he didn't wake up till 11 o'clock that morning, apparently. So the other questions that were asked were in terms of his demeanour. And basically they established that he was cooperative, he spoke coherently, he answered questions appropriately, and he had no problems understanding the conversation. Now, in terms of the cross from the defence, we had Alex Johnson doing the questioning here. Now, I got the impression the other day from what the judge said that he must have been still getting his accreditation in terms of as a criminal defence lawyer. Turns out he's actually had his accreditation for 4 years, I think it is, 4 or 5 years. So he is actually accredited. I think he was far better than Alicia Smith. He spoke clearly, he enunciated, he didn't rush. You could hear what he was saying, you could understand what he was saying. To be honest, I didn't like him. He sounded arrogant. He's doing his job though, so, what can you say? I will say, and this is something that I think may on some level impact on the jury. I know that apparently when you work for the state, you don't get as well paid as if you're working in private practice. But to me, and let me know if I'm just being biased here, if I am being a little unfair, but I think part of being a trial lawyer is creating a good impression with the jury. First of all, like I said, he came across as being a little bit arrogant. And that's something that I think some jurors are going to be turned off by. Not only that, let's talk about the ill-fitting suit. Okay, it wasn't like he was bursting out of the suit or anything, but watching him when he was cross-examining Detective Hunt, looking at and I noticed this with both the male detectives, they had these really nicely fitting suits that looked like they had spent a bit of money on them. Whereas this lawyer looked like he went and got his suit from Walmart. Now, I don't know if that's an appropriate comparison. We don't have Walmart in Australia, but I gather that's where you go for cheap clothes. And his suit looks cheap because it is ill-fitting. But, let me know if I'm being unfair saying that. Because like I said, I'm just going by Australian standards. I'm just going by my own perception. My perception of trial lawyers is that they are usually extremely well presented, well dressed, really good professional attire, someone who creates a professional image. And it's not what I've seen so far from these two defence lawyers. Like I said, I could be wrong. Let me know your thoughts. Feel free to tell me to stop being so biased, if that is what I'm doing here. Now, in terms of his cross of Detective Hunt, there was not really anything significant there. He tried to query the whole, how can you know that he'd only woken up an hour earlier? And this was one of many instances when it became clear that the defence really hadn't taken the time to properly listen to the interviews, because otherwise he wouldn't have asked that question knowing that the answer would have been that Stefan basically himself told the detective that's what time he got up. Now, next we had Detective Tagler, and I just want to point something out about Judge Carsten that I really liked, and I caught it with Detective Tagler. I didn't see if it occurred with the other detectives or the other witnesses, but what he did as she was going into the witness box was that he gave her a reassuring smile. I didn't really catch it that well here because it was zoomed out. You would have to basically watch that part of the video slowly and watch very closely, but he basically gave her eye contact and gave her a reassuring smile. Essentially, you're safe in my courtroom. And I thought that was a really good thing to see. I think this really does give me confidence that this case is in the right hands. Now, before I get into the nitty-gritty of Detective Tagler on the stand, my overall impression was that she was confident in her answers. She knew what was contained in those interviews, and she was confident enough to correct the defence when they gave questions that were inaccurate, when they were trying to twist the truth, or they just simply didn't know what they were talking about. This is why I take offence at that other creator basically claiming that she was destroyed on the stand. Because to me, seeing someone basically manage to deflect every assault on them doesn't count as them being destroyed. And essentially that's what she was doing. She was not brought down in any way by the defence, if you ask me. I did at one stage have a little bit of concern when they asked her about seeing photos on Stearns' phone. And my concern over that was she did seem to falter a bit when asked this question. But not only that, it seemed to be something that came out of the blue, something that had not been mentioned anywhere. And it kind of felt like the defence was going for a gotcha moment. You know, okay, well, you know, you saying here that, yes, you were looking at history of things and maybe that does cover history of phone calls and everything, but what about these photos? But then I thought about it and I realised that actually it was a pretty dumb move by the defence because, like I said, Judge Carsten has listened to the interviews. Obviously, he will have gone through all the documents with a fine-tooth comb. There is no mention in the interviews from Detective Tagler of her seeing photos. That's never mentioned to Stefan. And there's also no mention in the documents put out by the defence or the state in relation to these motions of her looking at photos. So that got me thinking, well, they haven't heard directly from Detective Tagler that she was looking at photos. It's not in any of the recordings. It's not on any documents. It's not mentioned by Detective Aosta at all in any of the recordings or any documents. So how could the defence know that Detective Tagler looked at a few photos? The only answer to that is that Stefan watched her do it. Why is this significant? Because part of what the defence pushed during this whole hearing was the claim that Stefan didn't see what Detective Tagler was doing on his phone. She's been asked about it and she said she was standing right next to him, meaning that he could see the whole time what she was doing on her phone. The defence is, without saying it outright, trying to skirt around that and say, no, you know, Stefan couldn't see what she was doing on his phone. But they basically shot themselves in the foot here. And hopefully Judge Carsten is as astute as I believe and will actually sit there and think the only way that they could know that Detective Tagler saw some of Stefan's photos would be if Stefan himself saw her access his photos. Meaning that shoots completely to pieces that part of the argument from the defence that it was all top secret what Detective Tagler was doing with Stefan's phone. The other interesting thing is, and this is something that I think we'll hear about in trial, but I found it a little bit alarming because she said they were photos taken on his phone on the day that Maddie went missing. Have a think about that. What could he possibly be taking photos of on his phone on the day that Maddie went missing? I hope I'm wrong. But the first thing that comes to mind is that there are photos of Maddie on that phone that were taken on the day that she went missing. And I'll let you think about that. I'm not going to go further with that because it is upsetting to think about. Now, let's go back to talking about Detective Tagler on the stand. Now, talk about stamina. They had her up there for over an hour. And yet, she kept basically slinging back her answers the whole time, didn't falter. Like I said, there was that one instance in terms of the photos, and now I realise that was actually a huge mistake on the part of the defence. But every other time, she didn't falter. She gave her answers. She corrected them when they were wrong or when they were trying to misconstrue things or trying to make her to make assumptions over things that she didn't know as truthful. I think she did a really good job. So let's talk about, first of all, her being questioned by Danielle Pennell. And I really like Danielle Pennell. I feel that she just gets straight to the nuts and bolts straight away. She doesn't mess around, and she knows what she's talking about here. So the first thing that she did was ask Detective Tagler questions that establish probable cause. We had the discussion of the tag readers not matching his story, not matching his timeline, not even matching the direction of travel. And then we also get the discussion of how Stefan told his story to Detective Tagler and the way that it was deceptive, it was contradictory, all those things that were wrong with his story, that was covered here. She managed to get Detective Tagler to explain that side of it. She also managed to establish that he was the last person to see Maddie. So these are all things that she basically questioned Detective Tagler about to show probable cause. The issue of the sleeping arrangements was brought up. So that was made clear as well in terms of probable cause. So she asked Detective Tagler all these crucial questions, which basically clearly demonstrated that there was considerable amount of probable cause for her requesting to look at the phone in the first place, and for them to later seize the phone. And then she addressed these claims of coercion and established the fact that for Detective Tagler, her uniform, so to speak, is professional attire. And Detective Tagler went as far as to say, like what I'm wearing right now. So she made it pretty clear, you know, I am dressed in professional attire. I'm not dressed in a police outfit. And she also established that Detective Aosta was dressed the same way. She brought up the issue of there being officers on the scene around the townhouse. And she basically established the fact that, yes, they were in uniform, But they were actually not in the same vicinity as where this interview occurred, and they were focusing on actually doing their jobs, not anywhere near Stefan, not anywhere near this interview. Sure, they had their firearms on them, but at no point in time did anyone actually draw a firearm. She also established the fact that they were outside in a car park. They were near the Lincoln. He was not handcuffed. He was free to leave any time he wanted to. So she made it pretty clear they were out in the open. Now, anyone with half a brain can see that. If you're being interviewed out in the open, then yes, you are free to leave. There was no attempt to corner him, no coercion, no handcuffs, nothing like that. He was free to leave. So she well and truly established that. And then came the question of his demeanour. So when asked about this, Detective Tagler said he was emotionless. No, he was not groggy or confused. Yes, he was well and truly able to communicate. He did respond appropriate to questions, and he displayed cooperative behaviour. She once again went back to this whole free to leave thing and made clear, was Stearns physically blocked in any way? No, he was not. Did he express any desire to leave? No, he did not. He also didn't try to end the communication in either a physical or a verbal way. So she's clearly established that there wasn't any duress, wasn't any coercion. He was free to leave should he have chosen to. She then moved on to the discussion of Stefan's phone. And again, clearly established a number of things. First of all, she established that Stefan did give consent for Detective Tagler to look at his phone. Not only that, but he entered his passcode to unlock it and handed it to her. She established location for everyone during that interview, which basically demonstrated that Stefan was standing shoulder to shoulder with Detective Tagler and was looking at the phone. And then you get the discussion of the looking at maps, looking at history, wanting to take a photo of his history. And she points out that Stefan never communicated any limitations or try to end the search of the phone. She then specifically questioned Detective Tagler about Stefan's Google Maps. And Detective Tagler points out that Stefan had said he uses Google Maps for pretty much everything. But when she looked, his Google history was minimal. There was not a lot of travel, and it was not consistent with his story. So she basically established that it was at this point that because of the inconsistencies, because of the lack of information on his Google Maps, that Detective Tagler asked to look at his history. And that's when she went to his call history and discovered there was not a lot of info. And Danielle Pennell confirmed with her that this was after she had requested to look at his history. She also confirmed with Detective Tagler that at no point here did he cease or withdraw his consent. There was no objection to what was happening here. And then we get the mention that when Detective Tagler questioned him about his lack of call history, that's when he brought up the factory reset. After which, because of all this, because of the inconsistencies, because of the factory reset, that is when she told him that she was going to hold on to his phone. And she actually did ask him twice, is that okay with you? And he expressed that was fine. There was a discussion of him wanting to be able to contact his father, and that she had explained that you could do that on Jen's phone. Now, one of the things that the defence was pushing was the whole thing of him not being allowed back in his car, not being allowed back in the townhouse, so poor little Steffi was cold. So part of the questioning here was around the townhouse and the Lincoln. Basically, at this point in time, he had only been requested not to re-enter the townhouse and requested not to go back to his car. And it was established quite clearly that he had been in and out of Jen's car all evening, and that after this interview he did go into Jen's car. Again, it was established there were no restraints on his movement at the end of this interview. He was not told, you have to stay on location. He was not told, you cannot go and sit in Jen's car. He was free to leave. And we know that him and Jen sat in that car for like 4 or 5 hours. Clearly, they weren't overly concerned about the need to leave. They were given privacy. They were in a vehicle, they could have left. The road wasn't blocked. And then we have them moving on to the second interview. And again, Danielle Pennell establishes that he was not restrained, he was free to leave. Yes, the detectives were still in their professional attire, not in like officer attire. No, they did not at any point in time take out their firearms or threaten to arrest him or pull out a taser or anything like that. She also established that his demeanour was exactly the same in the second interview as it was in the first interview. There were no issues with communication. He was cooperative. And she talks about when Detective Tagler explained that they wanted to download his phone, he consented. Not only that, but he also gave them his passcode for his phone. She questions Detective Tagler about how permission was granted, and she explained that she gave him the choice. We want to download your phone, we want to go through it. Do we have your consent or do we need to get a warrant? It is clear that it was him being given options, and by suggesting do we need to get a warrant means that he did have the option to refuse. And of course, this is something that the judge will hear quite clearly in the interviews. You can hear that in the tone of voice, it is not an ultimatum. It is giving him options. And she established that the consent was given twice. She clarified things. Now, the other thing that she established here, which is really important, is that Detective Tagler gave Stefan her card, her business card, with her phone number on that, so that he could contact her at any time. And she did say, at any time. Which basically means that had he come away from the interview and decided, actually, I want my phone back, there was the option that he could have contacted her and said, I want to withdraw my consent, I want my phone back. Now, maybe they'll argue that he was too afraid to do so, but don't forget, at this point in time, Jed was talking about getting him a lawyer. meaning that had he gone through and got a lawyer, maybe a lawyer at that point of time would have requested his phone back and said, we want you to get a warrant. The point is, he had that option. He had a way of contacting the detectives and saying, I want my phone back. And we actually hear the discussion, or we hear Jen conveying the discussion, where he said to her, should I have asked for it back? And she said, you'll make yourself look more guilty. Of course, that wasn't put in as evidence, so that's not something the judge will hear. But I think, based on everything else, I think he can actually use his intelligence, his critical thinking, to see exactly what was going on here. The other thing that is clearly established in the questioning was the fact that Stefan and Jen left the area directly after that interview, proving that they were free to leave, because they did leave. Now, moving on to the cross-examination. So we had Alex Johnson doing the cross-examination again. And like I said, he took a very aggressive stance with Detective Tagler. And she deflected pretty much everything. He was trying to push her to explain how Stefan and Jen got outside of the house. Obviously there, he was trying to establish that they were thrown out by coercion or something like that. And she was not going to play the game. She basically made it clear to him that she wasn't there. So she wasn't playing that speculation game. And then he tried a different angle, but you kept him from going inside his own vehicle. Again, she stood up to him quite well and explained it was because it was being secured for searching, and I asked him to refrain from going back in his vehicle. And I'm just going to play that little clip because I think it does show how good she was at basically deflecting these aggressive questions.
So, at what point, let me ask it this way, how did he get outside of the house?
I don't know. I wasn't there when he was outside.
To your understanding, how did he get outside?
I'm not sure.
The law enforcement told him to?
I wasn't there.
Okay. And when you're talking with him, at no point did you say, you can go back inside, right?
I did not.
At no point did you say, you're free to leave, you can drive away, right?
I did not.
Actually, and you kept him from going inside his own vehicle, right?
I did.
Because that was being secured for searching too, right?
At that time, I just asked him to refrain from going back in his vehicle.
Okay, so you didn't even tell him it was for a search?
Not at that time. I wasn't sure what we had at the moment.
Okay.
She didn't flinch. She kept eye contact with him the entire time. You didn't see her look away, look down. You didn't get like an increased blink rate or anything. She was solid. And she was not going to let him talk her into anything that wasn't accurate or wasn't fair. So even when he talks about her essentially not allowing Stefan back into the vehicle, she explains that it was because it was being secured for searching. When he asks, did you explain that to Stefan? No, because at that point in time, we didn't know exactly what the full situation was. She was honest. She didn't try to hide anything. She certainly didn't come across in a negative manner as far as I'm concerned. Now, one of the things that this lawyer did which really bugged me was his way of rewording things to make them sound insightful. And I don't mean insightful as in intelligent. Insightful as in challenging. To make them sound bad. So he starts talking about the phone consent, discussing the consent in terms of can she look at his maps? And then he asks her this question. Did you say, do you mind if I dig through your entire phone at this point? So he's trying to make a point that she did more than look at Stefan's maps. The thing is, like I said, the judge has heard the interviews. He knows the sequence of events. He knows that after she looked at his maps was when she questioned him, can I look at your history? So this is a pointless question to be asking. Maybe if you were asking it in front of a jury, you may be able to sway some jurors. But this line of questioning in front of a judge only makes them look like a complete and utter AWS. I can't say it because you know the whole issue with demonetisation. Like I said, sure, it may sway a few jurors. But the judge is just going to see it for what it is. He knows that's not the truth. He is intelligent enough. He is capable of critical thinking. He's capable of logic. These stunts, there's no point in doing them when it's the judge who's making the decision. Again, he tries pushing at Detective Tagler over her request to take a photo of his history. And still, she's not deterred, she's not put off, she stands up against him. So he's asking that basically that she'd asked to take a photo of the history, and he follows with not to take a photo of his home screen or his call history, it was his history. So he's once again pushing her for a response. He's trying to make her look like she's done something wrong. He's trying to make her admit that she's done something wrong. And she's not the least bit fazed by this and says, I did not take a picture of the entirety of the phone, just his history. And he kept pushing at her.
Timeline is, do you mind if I look at your maps real quick, right?
Correct.
At no point did you say, do you mind if I dig through your entire phone at this point, right?
I did not.
Okay. And then when you get to the next question, it's, do you mind if I take a picture of your history, right?
Yes.
Okay. Not take a picture of his lock screen?
No.
Not take a picture of his home screen?
No.
Not take a picture of his call history?
It was his history.
Not take a picture of his emails?
I did not.
Not take a picture of the entirety of his phone, just his history, right?
Correct.
Okay. And then when you get to the next thing, you say, is it okay, let me make sure this is right. Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google, right?
Yes.
And at that point, Mr. Stearns tells you that he is not logged into his Google, right?
Correct.
Okay. But then you keep pressing and you say, is it okay if I check?
I asked, I didn't press.
Okay. You asked if it's okay you checked?
Yes.
Okay. And at that point, it was just to check whether he was logged into his Google, right?
Correct.
Not going through the entirety of his phone.
Correct.
You never asked him, can I go through the entirety of your phone?
He was standing next to me while I was on his phone.
Okay, so it's your basis that he has to say no, you can just keep digging until he says stop?
Correct.
Really?
He was standing next to me and he saw what I was doing on his cell phone.
And did you ever ask him to go through the rest of your cell phone?
I did not.
Did you ever ask him to go into his call history?
I did not.
Did you ever ask him to go through his Google Drive on the phone, if it was even was it?
I never looked at his Google Drive.
Okay. But you were looking at the rest of his phone, right?
I looked at his call history and his Google Maps.
Okay, because you were trying to figure out that timeline, right?
Correct.
It's the only thing you were looking for at this point, right?
Correct.
Okay. Did you ever go into the photos on his phone?
Yes.
While he was there?
Yeah, he was standing next to me.
Okay. Did you ever ask him if you could go through his photos?
I did not.
Right. And when you're going through those photos, I mean, let's talk about that. How many of his photos did you look at?
I think it was maybe 2 or 3 of the day Madeline went missing.
Just to be clear, you're not just looking at like the big grid, you start going into actual pictures?
I don't recall if I actually clicked on any of the pictures.
Okay, so how do you know that you were just looking at 2 or 3 of
Because it has dates on, like if you look at the grid, it shows dates for pictures.
Okay.
So again, he's trying to push her to admit fault. And he's talking about her looking at things such as photos. And she points out that Stefan was watching her do that. And the thing is, we know that's the truth because that's the only way this lawyer would know that she looked at some photos on Stefan's phone. But each time he tries to push her to admit that she has done something wrong, she basically puts him straight. Stefan was right by me while I was looking at the phone. He did not withdraw consent. He saw what I was doing. Essentially, it's pretty clear that she was a little bit uncomfortable with that line of questioning, you could tell. But the thing is, like I said, he shot himself in the foot because he's talking about things that the only way he would know about them would be if Stefan said to him, this is what she did, which means that Stefan has admitted watching her while she was looking at his phone, meaning that he was fully aware of what was being looked at. He did not withdraw consent at any time while she was doing so. And if you look at what is being said here, essentially, she was still checking his history. That is what she had asked. And regardless of which way you look at it, whether it was looking at his calls, looking at his photos, she was checking his history because there was an irregularity with Google Maps. So she is confident here that she didn't do the wrong thing because she had his consent to check his history and he was watching her as she was doing so. And he continued to try and twist things around. So he kept pushing her over. You didn't ask to go through his call history when essentially she asked to go through his history. So, hello. And then he tried another one on her. When you took the phone, you didn't ask for the phone. Well, that backfired on him as well. I already had it. Because she had, before that, asked him to unlock his phone again. He unlocked it and handed it to her. That is essentially him giving permission for her to have his phone. So when she informed him that she was keeping the phone, she already had it. So that's put that bit out the window completely. And he just kept twisting information, asking about stuff that she wasn't involved in, she hadn't been there, didn't know about, trying to trip her up, trying to get her to speculate on things that she wasn't going to speculate on, because she was there to testify only about her part in this investigation with Stefan. The other things were not relevant to her. She knew that, and she stood her ground. And that's what you see throughout this entire cross. She stood her ground the whole time. He asks her if she gave Stefan a consent form to sign when she took his phone. And she replies with, I did not. Everything is audio recorded. Meaning that at that point in time, it actually wasn't needed because his consent is recorded. He tries to talk about the taking the phone being an ultimatum to Stefan, and she corrects him. I asked him 2 questions. he kept pushing her over the search, over the seizure of the phone. And she kept strong and pointed out, he gave us consent. So every time he tried to trip her up, tried to get her to answer that she had done something wrong, she was strong with her answers and she was clear. There was not one point when I thought, ooh, that's going to destroy the case. Quite the opposite. I felt that because she was such a strong witness, she was not going to be swayed, she was not going to be bullied, because essentially that's what he was trying to do. He was trying to bully her, he was trying to coerce her, which is ironic given that that's what he's accusing her of. He was trying to push her to come out with answers that weren't accurate, answers that suited the defence's narrative. And she kept pushing back and basically pointing out where he was wrong. And then he tried going at her with the medication angle. And this was beautiful. He asked her if he'd told her that he took medication because he couldn't sleep and he was stressed out. And she says, yes. He told me he took it the night before. So that immediately makes it clear that if he had taken medication, it would have been worn off by then. We've already established from Detective Hunt that he had been asleep until 11 o'clock. So he'd slept off his medication. Even if we're talking about the second interview that occurred at 12 o'clock, meaning that he'd only been awake for 12 or 13 hours. Well, most people only have 8 or 9 hours sleep, so it's not like, given that he had had medication the night before, he had had sleep, it's not like this whole sleepy side of things actually sticks. And she's basically put him in his place with the he had it the night before. And he tries the angle of, are you aware what Ativan does? And she comes back with, no, I don't take Ativan. She wasn't going to play that game either. She wasn't going to speculate over what Ativan does or doesn't do. Wasn't interested in playing that game. And he realised that line of questioning was screwed and gave up on it. Then we get the sob story of him being in flip-flops, shorts, hoodie, and he hadn't eaten all day. This, of course, also missed the mark because I believe at this point in time she pointed out that he had been in and out of Jen's car. I can't remember what was said about him not having eaten all day. I'm not sure if that was directed at Detective Tagler or whether it was just a statement made by him. But either way, my impression was that he came at her quite fiercely, quite aggressively, and that she basically rebuffed everything, and she was confident in her answers. And I actually saw several people, I was definitely on the docket when I was watching this, and I saw several people commenting on how well she did and how she was rock solid and could not be brought unstuck. So it wasn't just me thinking that. Now, then we get the redirect from the state and just clearing up a few things. Basically, just doubling down on the truth of the situation. Particularly in terms of, yes, there were other law enforcement at the apartment complex, but in that immediate area, there was only Detective Tagler and Detective Aosta, because that was something that was pushed by the defence to try and give the impression that basically they were trying to be intimidating. I felt that the redirect was, once again, succinct. It basically brought undone any of the suggestions made by the defence, and I think definitely the state once again came through as being the stronger side there. And then we get a question from the judge for Detective Tagler.
Detective Tagler, I've got a question. When you initially interacted with Mr. Stearns, you indicated that you were going to take a photo of his history. Is that correct?
Yes.
Did you take a photo of his history?
Yes.
Was that on your agency cell phone?
Yes.
Any follow-up questions based on that question? Stay.
No, Your Honor.
I thought that was a particularly interesting question from the judge. And what it said to me was that basically he saw through all the attempts to obfuscate from the defence and could see the situation exactly as it was. And he just wanted that clarification because of the mention of her asking to take a photo of his history, and he wanted that clarification to make sure that that had occurred. But basically, her saying, yes, that occurred, that is in support of the state's argument. So he's asked a question there that supports the state's argument. I feel that he is definitely seeing it as it is. I thought that the way that Detective Tagler handled herself on the stand made a significant impact on how this is going to be ruled upon by the judge. Her confidence in the fact that she was right, in the fact that she did nothing wrong, her unwillingness to bend to accusations, to bend to suggestions made by the defence, basically definitely shows her as a credible witness. That's what's crucial here. He was trying to discredit her. He tried really hard to discredit her. And she stood firm the whole time. She has come across as an incredibly good witness, as a credible witness, as a reliable witness. The fact that she showed no doubts at all and that she couldn't be swayed by the defence's attempts to turn the story around and rewrite the story is really good for the state's case. She was a brilliant witness, in my opinion. Let me know your thoughts if you've watched it right through. I'm imagining that pretty much all of you have watched the entire thing by now. But certainly, let me know your thoughts. I really thought that she did a fantastic job on the stand. Now, after Detective Tagler, we had Detective Aosta. Again, I have to admit, he doesn't look at all like what I pictured him as being like. Not only that, I think based on the comments that were being made in the chat section of the docket when he came up onto the stand, I think he now has a rather large female fan base. We'll just leave it at that. So, he definitely had a much easier time than Detective Tagler. So let's talk about Danielle Pennell first. She once again established that only Detective Aosta and Detective Tagler were in the vicinity of where the interview occurred with Stearns. She also established that Stearns had the ability to move about, he was not inhibited, there were no law enforcement vehicles preventing their vehicle from leaving the area, meaning the road wasn't blocked off. She also asked him about Stearns's demeanour, and we got the same sort of thing from him. He was very matter of fact, he was cooperative, he understood what was going on. She then clarified with Detective Aosta that there was no signs given to Stearns of the possibility that he would be arrested, or there were no threats of him being arrested. They did not remove guns from their holsters. They did not pull out any cuffs. They did not pull out any tasers. So she made it clear through that line of questioning that there was no coercion occurring, no threats occurring. She also clarified with Detective Aosta that Stefan did respond appropriately to questions. So, basically establishing that he was of sound mind, he wasn't impeded by drugs or lack of sleep or anything like that. And then the questions moved on to the discussion of the phone. And basically, his answers confirmed Detective Tagler's testimony. He spoke about her gaining permission, about Stefan putting in the passcode for the phone, about them standing shoulder to shoulder, and Stefan standing where he could actually see the phone. He also confirmed that Detective Tagler had returned the phone to Stefan before stepping away. And he also confirmed that basically when Stefan was asked to unlock the phone, he was cooperative. There was no coercion. There were no other officers in the proximity. He did it willingly. So she's just basically doubling down on proving there was no coercion. Things were done on the up and up. And basically, Detective Acosta's testimony backed up Detective Tagler. And then she moves on to discussion of the inconsistencies in his statements. She discusses with him that he was aware of the information that had been located on Maddie's phone, and that's significant too, in terms of probable cause. And there was also the discussion of him and Detective Tagler having reviewed the surveillance from the townhouses before the second interview. The surveillance which showed Maddie in the vehicle and which showed Stefan putting things in the dumpster. Again, that is demonstrating more probable cause and essentially showing that Stefan was sketchy AF and that they were well in their rights to suspect him. They had probable cause up the wazoo, basically. Plenty of reason to seize his phone. Plenty of reason to say to him, we want to download your phone. By the time you witness this guy driving around with a deceased child in his vehicle and throwing items in a dumpster just prior to doing that, then heck yeah, you've got probable cause. The cross-examination was inconsequential, in my opinion. He got asked about the amount of time that went by between the interviews and what him and Detective Tagler were doing during that time. And he explained about the surveillance and also spoke about them debriefing with their supervisors, their direct supervisors. And essentially, this established the fact that the decision to download the phone actually didn't come from Detective Tagler. It was a decision from higher up. One of the final questions that was given by the defence to Detective Aosta was with regards to a warrant. Was there a discussion with your supervisors regarding getting a warrant for the phone? The answer being no, there was not. To me, in terms of Detective Aosta as a witness, his testimony definitely backed up everything that Detective Tagler said. It certainly strengthened the argument of the state. In terms of the defence, I thought their approach was pretty soft. I don't think they came out with any punches here. Obviously, their target was Detective Tagler, but they didn't have any questions here that could have put Detective Tagler in a bad light. So it was a fairly soft questioning. I don't think they gained any ground whatsoever in the questioning of Detective Aosta. And I think they probably had put so much effort into figuring out what they were going to ask Detective Tagler on the stand that they just completely discounted Detective Aosta and didn't come up with anything worthwhile as far as I'm concerned. I think at this point, definitely, the defence really weren't helping themselves at all in the cross-examination. There was nothing that no admissions from Detective Aosta that could have shed a bad light on Detective Tagler, nothing that could have made her decisions look like they were the wrong decisions. So, after Detective Aosta, we then had someone from forensics come in, and let's admit, he did look like someone from digital forensics. Okay, so hopefully I can pronounce this right. So his name is Darko Stamec, spelled Darko and then Stameich. And he basically was questioned, first of all, about how the download is done. And he went through the whole process and explained that in quite a lot of detail. He mentioned how the data is extracted and then it is converted into a format that makes it readable for officers, and then it is uploaded into the cloud so that it can be accessed by detectives and officers. And when it is in that form, it is basically easy for them to read and they can see whatever they need to see. Now, then we get the discussion of the factory reset. And this is important. He explained that there are multiple steps for a factory reset on that model phone, so they specifically referred to that model phone. And he also pointed out that the button for updating that phone is actually in a completely different part of the settings from the location of the factory reset, meaning that it was not accidental. He then explained the process that when you are resetting your phone, you must log on to Google. And what occurs then is that Google will begin to repopulate the phone. That means, as you know, anyone who's purchased a new phone or may have factory reset their phone, it's basically re-uploading everything that's been stored in the cloud onto the phone. Now, something that comes up here that is really, really important is the discussion of how the phone is handled after it's been seized. So the phone was handed over to forensics at 2 o'clock in the morning, at which point in time it was put in airplane mode, basically meaning that it could not communicate with the cloud, with the Google Cloud, which essentially meant that were Stefan to then go into his Google account and delete evidence, delete images, destroy evidence on the cloud, it still existed on the phone. That is so crucial. That there gives you part of the exigent circumstances. Were they to not seize the phone, Stefan could potentially destroy everything because the phone would be in sync with the cloud. So this is something very, very important here, and something that I hadn't even thought about. So definitely a win for the state to have this witness pointing this out. There was really nothing in terms of a cross or anything here. And in all honesty, I think the defence was snoozing during this testimony, because they made some pretty dumb comments later on, which actually contradicted what was actually established here with this witness, and I'll come back to that. So they moved on at this point in time to the motion to suppress evidence from the Google warrant. And this is where it got a little bit difficult to follow because of the audio once again. So there was a question over the sufficiency of the warrant, comments over technical defects, and the judge asked for the defence to provide evidence regarding the sufficiency of the warrant. Now, it was hard to pick up what was being said there because it was muffled, but my takeaway was that the defence essentially said they didn't really have any evidence to show that the warrant was insufficient. And this seems to be backed up by the state, saying essentially the defence has not met their burden re-challenging the search warrant. They didn't produce evidence other than what they produced with regards to the phone, the motions for the phones. There was no additional evidence produced, and basically the judge was going to have to base his decision on the testimony that had already been heard. Now, it was at this point also that the state mentioned that they did have one more witness up their sleeve. And at this point they called in Tagler, who was the individual who drafted the search warrant, essentially. That's pretty much all that happened there. Basically, they asked her if she was the one that drafted the search warrant, then the warrant was entered into evidence. So I guess it was just about basically making sure the warrant was entered into evidence and following protocol. So it was a very brief appearance from her, more just following protocols, like I said. So then we get onto the final arguments for the three motions. Again, we get the defence claiming that consent was not sought or given for seizure of the phone, and claiming that there were no exigent circumstances.
As to Detective Tagler, the exact evidence that was elicited was that the detective had informed Mr. Stearns unilaterally that she was going to hold on to a cell phone. This was a declarative statement, not a request, and there was no opportunity to refuse the turning over of the cell phone at that point. Detective Tagler had the cell phone in hand, was clearly exercising dominion and control over the cell phone, and told the defendant straight up that it didn't matter that he wanted to get in touch with his parents or to continue getting in touch with his parents as the night went on, and simply dismissed Mr. Stearns' concerns and unilaterally seized the phone.
So notice the speech that he's using. He's talking about her unilaterally seizing the phone. Basically, it was all her decision, making it sound like she decided to do so regardless of everything else. It was all her decision. Let's bash Detective Tagler. Then he talks about her declarative statement and how she had dominion and control over the cell phone. And apparently he likes the word unilaterally because he used that again when he was talking about the phone. He also claimed that basically she had told him to get stuffed when he said he needed to contact his parents, which we know what is not the case. That was explained. Basically, he was told, you can use Jen's cell phone. It was pretty clear. It is pretty clear in the interview, so of course that is something that the judge will have heard and will probably listen to again. As for his claims of no exigent circumstances, he basically turns around and says that there's no exigent circumstances because the phone had already been reset. And then he claims because at this point the phone was essentially destroyed. And he's trying to say here that once the reset is done, there's no hope of getting anything after that. Well, he clearly, like I said, he must have been snoozing when the digital forensic guy was up there on the stand, because he explained about Google repopulating the phone and everything going back on the phone. He explained about putting the phone in airplane mode so that even if things were destroyed on the cloud, they were able to keep anything that had gone back onto the phone. So basically, he's just come out with this statement that is completely and utterly wrong, which is pretty weak. As for using words like unilaterally, declarative statement, dominion and control, that's already been proven in the interviews that that's not how it happens. But once again, this guy thinks he's trying to convince a jury who can probably be swayed by that sort of persuasive language, as opposed to a judge who is basically going to be ruling on facts, not on persuasive language. He's not going to buy into any of this, so it's a bit of a wasted effort, really, on the part of the defence. Unless, of course, this was a performance for the cameras, basically intended to persuade viewers, to persuade the public of this particular point of view, which is then when we get these content creators who turn around and start attacking Detective Tagler and saying she was destroyed on the stand, start saying, has this destroyed the case? Have police or have law enforcement basically made a massive error that's basically ended the case? All this stuff. maybe this was the whole point of it. Because we're seeing now several cases where lawyers are learning to manipulate public opinion basically through social media. So we certainly can't put that aside as a possible motive, but I'm also thinking that maybe he was just too much of a dummy to realise that he wasn't trying to persuade a jury. Now, the next thing that came out from this guy made me so wild. And that was his reasoning for why there were no exigent circumstances. Yes, he'd already said, well, no, in terms of the phone and getting things off the phone. Well, hey, the phone was screwed, so it was no longer an exigent circumstance to get the phone there, which, like I said, totally inaccurate, total BS. But what does he do next? He claims, let's talk about the missing child, essentially. He says there was no urgency because it had already been 20 hours since the missing report had been made. So apparently, even though at this point in time, Maddie was still missing, and at this point in time, they were still uncertain as to whether she was alive or not. And according to him, well, it wasn't urgent anymore because it had been over 20 hours. So, are you trying to say that once a child's been missing over 20 hours that it doesn't matter? And actually it was closer to 24 hours. Because actually it was over 24 hours. Because she was first reported missing at around about 5 o'clock. Stearns' phone was seized, here we go, at around 8 o'clock. So it was over 24 hours since this child went missing. They had no idea where she was. They had no idea if perhaps she could be lying injured somewhere in need of medical assistance. All they knew was that Stearns was the last person with that child, by his own admission. Not just by his own admission, by the mother's account. And according to this lawyer, that meant it was no longer urgent because it was over 20 hours. What a ridiculous argument. And what an offensive argument. He again went back to talking about how it was all a unilateral action from Detective Tagler, basically making it sound like she was some rogue cop who just did her own thing, pointing out that there was no warrant sought. Essentially saying, well, you know what, there was no warrant and there were no exigent circumstances, so there should have been a warrant. Even though his argument against there being exigent circumstances fell flat. He then turned around and said, well, there was no danger posed to the community from originating from anything on that phone. To me, that argument was neither here nor there. You could probably argue that there was, but honestly, it didn't matter because there were clear exigent circumstances established by the state. He was just trying to throw in an extra argument which, just to me, kind of fell flat. Now, you get Danielle Pennell coming up on the stand doing her rebuttal. And I found the way that she began to be extremely amusing. She basically said, okay, I have basically gone through all the cases stated by the defence. I have added them to a USB drive. Basically, this is for the judge to look at, with summaries, etc. So she basically did work for the defence, essentially. Pulled up the cases, pulled up the summaries, pulled up the case law associated with it, and pointed out that actually there was one case that I couldn't find. And basically put it onto the defence. You need to find this case and you need to provide it should you wish to continue to use it, cite it as, whatever. I noticed she didn't really waste time discussing these particular cases, but clearly she's outlined them for the judge, and I wouldn't be the least bit surprised if these cases that have been cited yet again have been misinterpreted by the defence, because it seems to be the way that they go. Then she continued to say, yes, we agree it was a warrantless seizure, but it is legally permissible when you have probable cause plus a warrant exception. This warrant exception being exigent circumstances. She mentioned that there is a vast amount of case law which basically defines probable cause, and the same with exigent circumstances. And then she starts to outline various things. Destruction of evidence. She says, case law shows that this exception is extremely compelling when dealing with digital evidence. Meaning that not only did they have exigent circumstances, but they were dealing with digital evidence, meaning that it really was crucial that they got hold of that phone. She then went and clearly outlined what to them consisted as probable cause and exigent circumstances. He was the last person to have seen Maddie. He had already attempted to destroy evidence by factory resetting the phone, and that occurred on the same day as Maddie's disappearance, making that even more crucial. She pointed out about the phone having been put into airplane mode so that if he went into Google Cloud to delete stuff, it wouldn't be lost from the phone. So essentially pointing out that had they not got the phone, had he actually got onto his Google account and deleted everything, they would have lost everything. So there definitely was a chance of evidence being destroyed. She then went on to say, basically, this shows they seized the phone because he himself admitted he had already destroyed evidence. It was clear that he had already tried to destroy evidence. And she pointed out, based on his actions, it was reasonable to believe that evidence might be destroyed before they could actually get a warrant for the phone. She then outlined everything that was known before the phone was seized, which well and truly showed probable cause. She spoke about his inconsistent statements to law enforcement about his whereabouts, about his timeline, all those sort of things. The tag reader information, which of course contradicted his stories. And she made it quite clear that basically case law establishes quite clearly that under such circumstances, permission actually isn't required to seize the phone. Even though he was asked multiple times, he gave his consent. The circumstances meant that legally they didn't have to ask permission. She once again points out the instances of case law that were misinterpreted. Now, in terms of the rebuttal from the defence, they really didn't actually address any of the things that were raised by the state. They simply restated their argument without even sounding like they even listened to the state. So again, he tried to argue that there were no exigent circumstances, that the phone had been reset, so essentially everything was already gone, which had just been pointed out that that is actually an erroneous assumption. So again, he wasn't listening. He tried to push for the unlawful search of the phone, tries to argue limited consent. He just kept trying to manipulate the facts to suit his argument. And like I said, this is not a jury that he's trying to convince. This is a judge who knows the facts and who's not going to be swayed by a lawyer who's trying to twist the facts. Again, he's claiming that Stefan wasn't free to leave and that Detective Tagler was pushing the boundaries, claiming that she was doing more than Stefan had consented to. Which maybe, on one hand, could be seen that way, but it has been established quite clearly now that in fact she was acting legally with what she was doing, and that Stefan was watching while she was doing that. He could have chosen to withdraw consent any time. Then he tries Stefan was not in a good mental state. It was cold, it was 50 to 60 degrees, which I forgot to look that up to see what that is in Australian terms. Okay, so that comes up as being in Celsius 10 to 15 degrees. So a little bit chilly, but he's pushing, it was cold. He was in flip-flops and khaki pants and a hoodie. Well, regardless of that, he spent so much time in Jen's car, for starters. It's not like they made him stand out in the cold the entire night. And really, do you hear anything in the recordings of the interview that sounded like because it was cold he wasn't in the right mental state, that he was suffering? There is no indication of that at all. So after this, Alex Johnson has finished just giving exactly the same argument and showing that he never really paid any attention to the state, Danielle basically comes out and slams down his arguments. She points out that actually the defence isn't arguing that Stefan did not give consent to look at his phone. She also points out that they were interacting in an open parking lot and that he had been in and out of Jen's vehicle. There is no testimony of threats or his movements being prohibited. She points out that Detective Tagler verified and continued to get consent for her to examine different parts of the phone. She points out that Stearns actually unlocked and handed the phone to Detective Tagler and did not at any point in time try to take it back. There was no attempt to limit consent. And then she points out that actually under the law, the scope of consent is measured by objective reasonableness. What would a reasonable person understand to be the object of the search? Essentially, having established that Stefan was of clear mind, that he appeared to be understanding what was going on in the conversations, he was cooperating, he would be considered a reasonable person, and therefore he should actually understand what is implied with the requests of the search. So she's made it pretty clear that Detective Tagler did not overstep the requests that she had made. She also points out that the defence has erroneously claimed that Detective Tagler walked away with Stefan's phone when she did not. She points out that in terms of history, there was no clarification as to what specific history was being referred to. She points out that there was no attempt at any point to limit what type of history Detective Tagler could look at. She also points out that there were points in the interview where there were pauses in the interview when he could have withdrawn consent. There were plenty of opportunities for him to withdraw consent. When he was asked to unlock his phone, there was no conversation about what was going to be looked at. He didn't ask, what are you going to look at? He just unlocked the phone. This is the second time when she came back, asked him to unlock his phone. He unlocked it, he handed it to her. He didn't ask, he did not limit the consent there. He unlocked his phone and handed it to her. Essentially, she could have looked at anything at that point in time. Danielle Pennell also pointed out about them gaining the additional info before the second interview, which added to probable cause. And she pointed out also that the phrasing is clear when Detective Tagler is asking to download his phone. And it would be clear to a reasonable person that they could refuse consent. He was given choices. Do you consent to this? Or should we get a warrant? It was a choice. It wasn't an ultimatum. And he agreed and he put in his PIN. She also highlights the fact that after the interview, Jen and Stefan left the location in Jen's car, proving that they were free to leave, and they did so. And she hammers in, most importantly, Stefan believed there was no incriminating evidence on that phone because he had done a factory reset. So he felt confident handing it over that nothing would be found. Now, it was at this point in time when they went into their final arguments over the warrant search, the warrant for the Google search, and this is when we got dropped out. So we didn't hear the arguments, but I think we can pretty much tell from what was already said. Basically, the defence team really didn't prove their case there at all. They didn't provide any evidence because they basically had their case law wrong from the beginning, and their fruit of the poisonous tree argument does not apply. So we can be confident that at the very least, that motion to suppress evidence from the Google warrant is going to be denied. Personally, I think that all those motions will be denied. And we will hear that from Judge Carsten hopefully soon. Now, let's talk about that. Now, this is basically minutes of the criminal appearance order and of this recent motions hearing. So here we have a change of court dates. Defendant is hereby ordered to appear the 2nd of July for pre-trial, 14th of July for jury trial. I'll come back to explaining why that's changed shortly. It is not, as suggested by some content creator, because of something huge that the defence has. It is nothing to do with the state or the defence. It's got nothing to do with new evidence. I'll come back to that and explain. Now, here we have talking about the appearance. Hearing held on the following motions, which we know. So we've got the motions mentioned. Defendant present with counsel, sworn and testified for the defence, Stephen Stearns. Then you have the witnesses for the defence listed, and you have exhibits listed that were entered into evidence. Arguments made by both parties. Court reserves ruling on all three motions. Court will issue a written ruling. So basically what that is saying is that Judge Carsten didn't make a ruling then and there. He is going to basically go through it all, and then he will issue a written ruling. So something that we will all be watching closely for in the near future. Although, like I said, I feel confident that the ruling is going to be that the motions are denied. I think there may be a few things that he points out that perhaps could be done better in future by law enforcement, more so to appease the defence. I could be wrong by that. I do feel fairly confident that the creator, who is basically going flat out against Detective Tagler and making her out to be the worst person in the world, is going to be disappointed by the contents of the ruling. Okay, what's important here is the explanation for why the dates have been changed. Second line, pre-trial and trial reset based on unavailability to try case within current trial period. Meaning that someone is essentially double booked, whether it is the judge or the defence or the prosecution. Someone is double booked. They cannot try the case within that trial period. They've reset the dates. Based on the wording, I'm going to presume that that is the judge who is unavailable. So, no to that creator who's claiming that there's some huge evidence that the defence has got that's why it's delayed. No. The hearing the other day, the motion to continue was a motion to continue for this motion's hearing regarding the phone evidence and the warrant evidence. That has finished. There was no other motion to continue. The reason for the change of date is basically a clash. Somebody is unavailable during the trial period that was originally set. That's all there is to it. It's no big secret, no big drama, nothing that is anything of concerns in terms of prosecuting the case. Again, I'll drop that document into my Patreon. If you are new and you're not familiar with my Patreon, it's free to join and the documents are free. You just have to put in your email address and join, and then every document that I upload is there and available for you to have. Go through, copy it, put it in your own folders, whatever. That is the sole purpose of me creating my Patreon, to share documents. So yes, there is I think there's a $1 tier and a $2 tier should you wish to support my channel, but it's not something that I ask of people. I am just simply putting documents there because I appreciate some people don't have the time to go chasing for documents themselves. Some people perhaps don't have the wherewithal to go chasing for documents themselves. It's just easier to have them all in one spot. So, that brings us to the end of this video. I seem to have gone, well, not quite as long as the actual hearing, but I've gone for a while. I hope I've provided some clarity in terms of the hearing. I hope I haven't waffled too much, although that seems to be the way I go, isn't it? For anyone who hasn't watched this motions hearing and wishes to do so, I will provide the link to it's WRKR or something like that. That is the best coverage I found after the fact of this hearing. They have the best audio, best visual, all that sort of stuff. So I'll put that link down below for anyone who does wish to go watch that. I will also add that particular version to my Maddie Soto case files, which is basically where I've got all the uninterrupted interviews, news reports, press conferences, all those sort of things. So I will add that there so you can find that way also. So I'm really keen to hear your thoughts, your observations on this motions hearing. Also, feel free to express your opinions. I don't expect everyone to agree with me. I don't claim to be right. I'm just sharing my opinions. So certainly feel free, if you disagree with me, to say that in the comments section. I'm definitely looking forward to seeing what everyone has to say about this motions hearing, what your observations are. Now, with these two hearings out of the way, with Touchwood a healthy puppy now, I should be able to get back onto my assessment of the derivative use interview tomorrow. So that should be tomorrow's video, barring any other interruptions, disasters, whatever. So fingers crossed. Thank you for your patience with the delays with my videos. I know a lot of you look forward to my videos and anticipate them. So to have 2 days with nothing, I can imagine, must be a little bit frustrating. So I do apologise for that. So on that note, if you're new to my channel, please subscribe. Also, please hit the like button. And of course, please leave a comment below. Thank you, and I'll catch you in the next one.
Into